Hi, this is Bootleg Legal, and we're going to talk about privacy policies and terms of service, especially under the GDPR and CCPA.
These are huge now because everybody has a website, and the law is famously behind tech in every way. Everything that happens in the tech world and it's sort of any advancement in society that happens rather fast, the law is like 5 to 10 years behind in figuring out well, how do we regulate this, right? Partly because bureaucracy is slow, but also law firms and the legal industry generally is pretty immovable because it's run by the old guard who've been around a long time, who may not be the ones who understand the developing tech as much as younger generations. And because of this, we see this massive lag that happens, which we've seen with privacy and data collection. And there are some tremendously terrifying videos and Netflix specials about what is happening to your data. Everything from location services to every single thing that you buy, to everyone you talk to things you say, even when Alexa's turned on, right? These are all things that are collected. And there's been virtually no regulation up until recently. These companies just had a heyday with it. And as a reaction to the mass commoditization of your data, countries and states are starting to pass privacy regulations very late in the game. The first one was the GDPR by the EU, the European Union. You are all probably familiar with this because when it went into effect a year and a half ago, everybody got an email from websites they frequented saying, our privacy policy has been updated, and now you get that stupid little cookies pop up. That's the GDPR, seeking to regulate data collection. And then now we have a California version of the GDPR, the California Consumer Privacy Act, that recently went into effect. And then you're going to have other states doing it, probably going to have federal legislation. It's going to be kind of a nightmare. Initially, California's regulatory system for the CCPA would allow for a private right of action in case you violated it, which would mean that any attorney that wanted to could just peruse websites, find any websites that weren't in compliance and just shake them down for cash, much the way that what we call the IP trolls do it. So we were really worried that this was going to result in mass liability. But the good news is, before it went into effect, it was slightly changed to where now the private right of action is for data breaches, which of course is a good thing. You want people to be able to have private right of action for when a company allows a data breach to happen. But it's not necessarily for whether or not it's not going to let somebody sue you just because you don't have necessarily the right language on your website. So what does this really mean? If you collect any data, which you probably collect cookies through wherever your hosting service is, you have to have certain language to comply with both the GDPR and the CCPA and all the forthcoming privacy regulations. Everyone's like, whoa, GDPR, that's Europe. Why does that apply to us? It applies to any website that can be accessed by a European citizen. So I've never actually seen the GDPR or anyone in Europe come after local attorneys for failing to comply. But the law is new and unpredictable. And frankly, the rules required by the GDPR are likely going to be required by most states in a short amount of time. So it's a good idea to get ahead of this and to basically have a privacy policy that complies with the law. The CCPA, the California law, doesn't apply to all businesses, mostly larger companies or anybody that's involved in selling data. It's a little more nuanced than that, but this is probably not something you should tackle on your own, but it's probably also something that, unless you are in the business of selling data, is probably something that can be done fairly cheaply by an attorney. This is an increase in the cost of doing business. There's no way around that. But I would argue that, it's a net positive because we're in a world where people can do whatever they want with your data. And so it's generally a really good idea that the law does something to address and regulate that. And at least these laws don't even go that far. They basically just require disclosure of the manner in which businesses are going to be using your data. Terms of service. If you have an app or you provide services like via your website or via your app, your terms of service on your website is very important, or terms of service in your app are very important. They are your client service agreement or your customer service agreement. They are the rules that govern your relationship with anybody that is using your website or your app. So you can limit your own liability. You can limit your exposure to them on so many different things. You can spell out the relationship and the way that you want it. And these are what we call adhesion contracts. One party writes them, the other party doesn't get to negotiate or edit them. If you want to use my app, if you want to use my website, you have to agree to my terms of service. So it can be really beneficial to use them basically to limit your liability and your obligations to your clients or customers or users, as the case may be. So these generally, again, don't take a very long time to prepare, and they're worth their weight in gold if you are doing business via your website or via your app, because otherwise you don't have any other way to form an agreement with your users. And so you're basically stuck following basic common law, and you're not actually in charge of the terms of that relationship. So you want to have both a privacy policy and a terms of service prepared for any website or app that you are basically offering services or goods to customers on. And I do recommend having attorneys work on this, although, you know, it's such a new area that not even a lot of attorneys are probably up to speed on all the latest requirements. This is going to require somebody who keeps their eye on a moving ball, because state after state is going to pass similar privacy policies. There's probably going to be federal legislation if there isn't proposed legislation already. It's going to come down the pike fast, and you need to stay on top of it. If you're a smaller business, they're probably not going to come after you for any violations. But if any states pass laws that have a private attorney general statute that allow basically class action attorneys to sue on behalf of the state if you violate that state law, then you're going to see a whole lot of lawsuits towards any companies that are perceived to have deep pockets. So again, might be worth a risk if you're a small company, if you don't do a lot of business through your website, if you don't offer services or goods directly on your website, it might be worth the risk to not do this. This is an area that you could save money, but I will say that eventually you're going to have to do it anyway. And it might be a good idea to get out in front of it.